My name's Joan Woodard, and I'm your hearing examiner this evening. The purpose of this hearing is to allow me to receive testimony and evidence on the matters that are pending. I make a recommendation only to the county commissioners. I do not make the final decision. I will be submitting my recommendations to staff within 2 weeks of this evening's hearing. The application will then be scheduled for deliberations before the county commissioners. If you wish to give testimony, I need you to fill out the sheets in the back of the room. And when you come to the podium, please remember to give me your name and address for the record before you begin your testimony. First, staff will introduce the application. Then we will hear from the applicant. After the applicant's testimony, we will then get into the public comment sheets. We will hear from those who are in favor, those who are neutral, and then those who are opposed. The public not speaking will be read into the record. We will also then go to Zoom to see if there's anybody there who wishes to give testimony. We will then give the applicant or their representative an opportunity for rebuttal of any testimony stated into the record from the public before we close the public hearing. After that point, I will receive no more testimony. The time limits are 30 minutes for the applicant's presentation, 3 minutes for public testimony, and 15 minutes for applicant rebuttal. We have a timer and you'll hear a noise, so please respect that and don't make me cut you off. Thanks. I would ask that you direct all of your testimony to me and not to the audience. Are there any questions regarding this evening's proceedings? Not seeing any, we will begin. Our first case this evening is case number VAR 24-0012.
Good evening. For the record, Vlad Finkel with Kootenai County Community Development. This is a request by Jorian Vries as well as Wade Skeels for a front and rear yard setback in the commercial zone. The subject property is located in Bayview area. It is not a waterfront parcel, but as you can see, it's in close proximity to Pend Oreille Lake. It's quite unique. The property is zoned commercial, whereas the other parcels to the east, west, and north are zoned restricted residential. I do not have, I'm sure you're going to ask, why is it that this property is zoned commercial? I do not have that information. This is what our county records show, and for the review of a variance application, we did not have to do a significant level of research to determine the reason why this project site is zoned commercial. But it is important to make that distinction because the setbacks are quite different in the commercial zone in comparison to the restricted residential zone around it. The main difference is you have a 35-foot setback instead of a 25-foot setback from the front yard property line. And then in this case, you have a 20-foot setback, whereas typically you have a 25-foot setback for other residential parcels. The subject property will gain access off of Horseshoe Lane. Now, Horseshoe Lane is partially located within a public right-of-way as it heads south towards Pend Oreille Lake. However, on the north end of it, where it intersects with Cape Horn Road, it is actually outside of the right-of-way. The road is actually further west. Now, staff has done some research and has reviewed the court order that was signed in 1978, granting Horseshoe Lane as a public right-of-way for the benefit of the general public. And based on the court determination, even though this road is located on a fee simple parcel of land, it is still for the general public use, and it grants. It's our understanding that it grants the applicants access off of Horseshoe Lane. A portion of this right-of-way is currently undeveloped, but it does bisect the property. And based on the code requirements, if the road is located outside of the right-of-way, but the right-of-way is located closer to the property line, the distance for setback calculation is from the right-of-way, which would be this property line here. The applicant has to measure east 35 feet in order to start construction. So here are some photos of the property. It is fairly level. It does slope towards the lake. They have a small portable teepee on it, but for the most part, it's just a grass field. This is Horseshoe Lane as you are looking north toward Cape Horn Road. So this is the proposed site plan. What the applicants are requesting, they want to be 10 feet from the edge of the undeveloped right-of-way, and they want to be 10 feet from the rear property line, which is the east property line. So they're seeking a 10-foot rear yard setback and a 25-foot front yard setback in order to construct their residence right in the middle of this narrow and somewhat unique parcel. It's got a very irregular shape. This is the rendering of the residence that they would like to build. Going back to the site plan, I did want to point out that based on staff's calculation, the width or from front to the back of the property is approximately 46 feet. Well, if you consider a 35-foot front yard setback and a 20-foot rear yard setback, those two setbacks would overlap by approximately 10 feet because you need a minimum of 55 feet width just to have those setbacks touch, and then you would need to have the property be substantially wider in order to fit a residence on it. So one of the factors for an undue hardship in this case is that the property is very narrow. One may ask, how is it that staff determined that this is the front yard setback along the public right-of-way for Horseshoe Lane versus Cape Horn Road? It has been office policy for many years that the front yard property line is the property line that intersects with the primary access to the property. So that being that said, because access will be off of Horseshoe Lane, the western property line has to be the front property line, not Cape Horn Road. Now, the applicant submitted communication with the Lakes Highway District Director with the discussion of whether they could have a separate access point off of the undeveloped portion of Cape Horn, off of the unbuilt portion of Horseshoe Lane right-of-way. And because of the close proximity and the curvature of the existing road, they would not grant them a separate access to have these be this property line, the northern property line, be the front yard setback. If that was the case, obviously they would not need a variance. But like I said, the orientation of setbacks is based on the point of entrance, if that makes sense. During the agency comment period, we pretty much got all the agencies to come back either in support or with certain requirements, like our building division will have building permit requirements. The only agency that did not submit a response was Bayview Water and Sewer District. Now, in speaking with the applicant this morning, they advised me that they already have a meter on site and they do have one hookup available, so it's non-issue. We'll get that clarified during the building permit process. So because we didn't get a response during the variance process, I don't think it was necessary to put this project on hold or delay the review process. That can be accomplished during the building permit stage. So during the public comment period, we got a total of 10 comments, 8 in support, 1 in opposition, and 1 neutral. I did receive a number of phone calls from the adjoining HOA, the Cape Horn Waterfront Association, with concerns. I think a number of comments that I received I find, and perhaps if anybody is available or on Zoom or here physically, they could provide further clarification. But I think there was some misunderstanding. The folks just didn't understand the scope of this project. There were some concerns that the road perhaps could be blocked with the approval of the variance. We don't find that to be the case. Clearly, the residents will be a distance away from the actual physically built road because it's separated by the right-of-way. We don't find that to be an issue. There's not going to be any reason to believe that the road will be blocked at any point during construction or after the fact. Furthermore, as I already explained, the undue hardship is based on physical characteristics of the site, being that it's constrained by how narrow the property is and the irregular shape of the lot being bisected by horseshoe lane right-of-way. The property is less than the sum of the prescribed setbacks from the front and the rear. And we find that having the structure placed centrally within the parcel 10 feet from each front and rear property line is actually going to make the residence centrally located, and it's actually going to it's not going to be a detriment or create an impact on the adjoining neighbors or the existing public road. And we find that that is a good reason to support this application as presented by the applicant. I stand for any questions that you have for me at this time.
I don't have any for you, Vlad. Thank you. And do I have applicant representatives here?
The applicant
Yes, I'm here on Zoom.
Oh, okay. Would you state your name and address for the record and tell us what you have to say?
Yes, thank you. My name is Wade Skeels, and my address is 20252 Big Canyon Road in Middletown, California. And I'd like to thank everyone for being here for this very important variance request hearing. My family has co-owned this property with our best family friends for 26 years. We have spent our summers there ever since, and we love our lake property and our neighborhood at the lake. I can assure all of you that we plan to keep our place on the lake beautiful and welcoming, and we will continue to be the best neighbors we can be. As we are quickly approaching our 60s, we will become less adaptable to camping, and we want to spend more time at the lake. I want to thank you, Vlad, and all county planning staff who have assisted us with our variance request over the years, to include Vlad Finkel, Mel Palmer, Zach Trevino, and Ben Tarbuton. I'd also like to thank Lakes Highway District for their assistance and support, to include Joe Weist and Eric Shanley. Also, Vlad, thank you for explaining very well our hardship request due to our site characteristics. This hardship is not self-imposed. Lakes Highway has determined that access to our lot is via Horseshoe Lane, as described by Vlad. This orientation makes our front yard from Horseshoe Lane. Our lot depth is 60 feet, and as explained by Vlad, diminished by the right-of-way I'll describe in a minute. A 35-foot front yard setback and a 20-foot rear yard setback leaves no viable room for a building footprint. Here, further adding to our hardship, we have an unusable upper portion of a right-of-way across our lot, so that our front and rear setbacks would actually overlap. We've been told by Lakes Highway that we can't use the right-of-way from the front, from Cape Horn Road, as described by Vlad, as it's too close to the existing Horseshoe Lane encroachment. Because of these physical characteristics, the strict application of the zoning ordinance would create an exceptional and undue hardship upon us as property owners. Our variance will not adversely affect the use of adjacent property, nor will it change the character of our residential neighborhood. Our variance will not adversely affect the health, safety, and welfare of the citizens of Kootenai County. As Mr. Finkel explained, our variance request includes a 10-foot front yard setback from the easement and a 10-foot rear yard setback abutting our neighbor's 10-foot side yard setback, in keeping with the residential nature of the neighborhood. Just as an aside, we love that neighbor. She's like family to us. We've been spending time with them every summer. They are some of our dearest friends. So we have everyone around us interest as best we can as we request this variance. As I've explained, due to our lot orientation and with these exceptional characteristics of narrowness and shallowness of our lot, we are respectfully requesting a variance to allow us to build our home. And also quickly to follow up on Vlad's presentation, yes, we do have water service and a meter with Bayview Water and Sewer, and our lot has an approved septic permit through Panhandle Health and an installed septic system from around 1978. I'm sure we'll need to rework that if we were fortunate enough to be granted approval, but we do have a permit from Panhandle Health for that. Our project, in closing, will have no impact on Horseshoe Lane or any person's access to their properties or the lake. Thank you for your understanding and consideration of our very important variance request. I appreciate your time. Thank you.
Thank you for your testimony, and I'm sure the county folks really appreciate your kind words to their efforts as well. They don't often get that.
They have been great, and it's been quite a few years back and forth, not intensively, but we've contemplated this for quite some time, and every one of them has been quite amazing, frankly.
Good to hear. Thank you. Okay, now we are ready for public comment. I have, is it Janice Pedersen in favor, may wish to speak? Okay.
Do you want the mailing address or the site address?
You can give me either one.
Okay, my name is Janice Peterson, P.O. Box 605, Bayview, Idaho. Is it possible to bring up the other screen that shows that one? Okay. So my husband and I live the third one over.
To the right
To the right.
on the screen that says 001?
Yes.
Okay,
Yeah.
thanks.
And we completely support their request for the variance. This piece of land has been a problem for them. And originally, probably the reason that it's red, because that means commercial, right? Originally, back in the 70s, it was part of the Cape Horn Waterfront Association. That piece of land, when it became, well, it was Cape Horn Properties. And then that piece, when it was all subdivided and the Cape Horn Waterfront Association was sold off to 30 owners, in the process, Parcel G is what we called it, was sold, was separated from the Cape Horn Waterfront Association property. But apparently it still remained commercial, as it probably had been, because it's red there. So that was, I think that's a clarification, but that was back in the 70s.
Okay,
So,
thank you.
yeah, so we support.
Thank you. Always helps to have a historian present. And Robert Peterson in favor may wish to speak? Okay, thank you. Anyone on Zoom?
Madam Chair, we do have a couple members on Zoom, but I don't know if they're here for this. Jorian, do you want to speak to this case? Go ahead and unmute yourself. We have two Jorians on, so if either one wants to unmute themselves.
Okay, probably our next two cases. Okay,
I think that's husband. I bet that's husband and wife on there. Jorian and Marnie are probably on separate Zooms.
okay.
I'll bet.
All right. Applicant, you may have a moment for rebuttal if you'd like.
Well, just to say that we don't know why it was zoned commercial, but we don't. It doesn't matter to us except that it challenged us a little further, or maybe more, quite a bit further with the variance request of setbacks. We intend to build a home very much in keeping with the neighborhood, a modest home, 1,700 square feet. So setbacks are, trying our side yard. Our rear yard is matching our neighbor's side yard. Our orientation matches her orientation, so that will feel very very normal as a characteristic of the neighborhood. That right-of-way has been a challenge for us since the beginning. Some people were mad at us when we first got there, and that took about 10 years, and then I think people have finally grown to appreciate us or not, but we all seem to get along pretty well. That we've been told by Lakes Highway that we can't use that right-of-way, and that's fine. We don't have any issue with that, but I just want to say that then means that while our variance request is 10 feet from that right-of-way easement, which is there, so that's the right ask, in actual physical terms, we would have more or less a 25-foot front yard distance from the horseshoe lane edge of roadway to our house visually, which matches the flavor, the 25-foot front yard residential flavor. So people should not be concerned that we're zoned commercial. We're trying everything we can to stay very much residential.
Okay. There being no further members of the public for comment and all testimony has been received, we will close case number VAR 24-0012. Thank you. And our next case is CUP 24-0013.
Good evening, Madam Hearing Examiner. Justice Mac George, planner of Kootenai County for the record. Here I have CUP 24-0013 on behalf of the Wood Family Trust for a private family cemetery. Here you see a general aerial vicinity map. The site is indicated by the gold star to the north, just west of the city of Rathdrum, and is outside of the Rathdrum area of city impact. Here is the aerial image where the burial site is proposed. The property in question does include it seems to be mapped as two parcels according to the assessors, but for land use purposes it is one parcel, and the burial site is highlighted in yellow to the southeast. The yellow line is the proposed access easement it's 60 foot wide via instrument number depicted there, if you can make it out. And that is actually taken from West Highway 54, excuse me. And here is a photo of taken looking toward the burial site. This photo is actually taken from the east looking west, and you can make out what the actual easement looks like physically. And then this is taken from the burial site looking to the east. And then you can also make out another burial site on a neighboring property to the east as well. This is another photo looking to the easterly direction toward the property line, looking at the existing burial site again to the neighboring property. This is the north side looking south of the proposed area. This is a zoning map. It's split zoned. The north side is the rural zone. The south side is the agricultural suburban zone. The agricultural suburban zone does require a CUP in the code. However, there are no specified performance standards in the code. This is the applicant's site map. Again, it's showing the same thing, access gained from West Highway 53 to the southeast, and then the access driveway is outlined in black, and then the burial site outlined in red. And it's about 1/3 acre in size. The public agencies that were solicited, none of them really provided any concerns. I would say, speaking with Idaho Department of Health and Welfare over the phone, they recommended that we solicit comment from the Kootenai County coroner. While the Kootenai County Coroner is not a regulating agency, they did provide some recommendations, more like best practices, that we have implemented as conditions of approval. There were 3 public comments in total, 2 in support of the request, 1 neutral. Additionally, another public comment was submitted in support of the request as well. I'll give that to you.
Thank you. You want to?
And entered into record as HE 2001. Thank you.
Overall, the staff analysis, community development believes that all the required findings have been met for a conditional use permit for a cemetery. And we support the applicant's request with the conditions of approval as recommended. We did also are recommending an additional condition that the applicant locate all burial sites outside of that 60-foot wide access utility easement that traverses the south property line, and I can give that to you as well for the record.
Thank you.
Entered into record as HE 2002.
Here is the site plan once more, and here are the required findings if you have any questions.
I don't. Thank you, Justice. Rand Wickman for the applicant.
Good evening, Madam Hearing Examiner. Rand Wickman for the record. My address is 2992 Gotham Bay Road, Harrison, Idaho. I am happy to be here representing the Wood Family Trust. I have known this family for a long time, and they are actually one of my favorite clients. There is not a group of nicer people on the planet as far as I can tell. And this application is about as simple and straightforward as I ever get to participate in. It really is. The Wood family used to own quite a bit of property, a couple hundred acres in this area. Their family donated the property to the Skeet, which is next door, which is kind of like a monastery. You may recall, I think you were the hearing examiner on that when we ran that through the CUP process. They also have a cemetery in there that you may have seen on the pictures or on your site visit. You know, that's really right adjacent to it, just kind of in this area here. The applicant wanted to have their own cemetery. They initially thought when they dedicated that property to the Skeet that they would be able to use that for their family. The Skeet has very stringent rules, and you have to be a practicing Orthodox member of their church. And while that works for my client and her recently deceased husband, it does not work for their children because they are not active in the church. And so she wanted to get this cemetery set up so that they could have their family together on this property. They are really surrounded by the Skeet property. This is owned by the Skeet. There's a conservation easement on this piece. It comes up under Jeannie Wood's name or the Wood Family Trust name. Might come up under Jeannie's name. But it is owned jointly with her and the Skeet, and this is also comes up under the Skeet name there as well. And so I think that will remain essentially an open space in perpetuity. The St. Herman of Alaska Skeet is not known for being developers. So I suspect that will stay largely as it is for a long time. The agencies, as Justice indicated, do not have any concerns with this. The neighbors don't have any concerns with this. There is surprisingly little regulation when it comes to cemeteries, and and burying people. You would be surprised, and I can recall being confronted with that question when I was here in David's position. I recall vividly the day one gal showed up in the office, and her dad was in a casket in the back of that pickup truck, and she wanted to know if they could bury her or bury him on their property. And so, other than the zoning issue, there really is no other governmental entity that regulates such things. It's really quite surprising. There's a lot of there's plenty of regulation about caring for deceased and the procedures to get that all processed through the coroner and death certificates on all of that. But the actual burial part of it is essentially unregulated, at least in Idaho. I don't know how it is in other states. At any rate, I think this is a simple, straightforward request, and it truly is just for this applicant's family. It will not see much activity. Frankly, no one will ever be the wiser, when burials occur there. But it was important to this applicant to make sure that they all had it properly permitted. And so with that, unless you have questions of me, that's all I've got for you tonight.
I have no questions.
Thank you.
And I have no public comment sheets. Do we have anyone on Zoom who wishes to speak on this matter?
We just have staff on Zoom, Madam Hearing Examiner.
Okay. Then that will conclude our hearing this evening on CUP 24-0013. Thank you. And we move on to case number APP 24-0001.
Good evening, Hearing Examiner. Blake Zetter with Kootenai County Committee of Development, introducing the case APP 25-001, Appeal of Administrative Decision by the Director. Just to kind of give some context for my presentation, I will be introducing the general context for what was approved. The approval was for a 3-lot minor subdivision, as well as introducing the appellant's case. That is the first half of my presentation. The second half will be the staff analysis and recommendation. So the subject property where the 3-lot minor subdivision was approved is located in Cougar Gulch, just west of downtown Coeur d'Alene. As shown in this aerial imagery, you can see that the public right-of-way off Clemetson Road here comes up and provides access to the subject property. In addition, you will see that the property is developed with a residence and several accessory structures on the north end here, which actually get access off Reynolds Road as it connects to Clemetson. The subject property is zoned agriculture suburban, which has a 2-acre minimum. Surrounding lots are in orange, are zoned rural, which have a 5-acre minimum. So to get into some specifics of what was approved, we have 3 lots here. Lots 1 and 2 will be served or proposed to be served by a common driveway as well as a common well. Individual septics for all 3 lots. Lot 3, which is already developed with the aforementioned residence and accessory structures, will retain its access off Reynolds Road here as indicated in the plat note. The decision to approve the minor subdivision was done on November 1st, 2024. The appeal was submitted on November 27th on the basis that the parcel is subject to CC&Rs that require the subject parcel to have a 5-acre minimum. It should be noted that the parcels proposed here meet the 2-acre minimum of the agriculture suburban zone, but are less than 5 acres. We did receive 3 comments in support of the appeal, and I stand for any questions before I let the appellant make their case. Oh yes, my apologies. The appeal, we were given some additional documentation on Tuesday of this week, and staff unfortunately has not had time to review these documents as related.
Thank you. Okay, so the brief in support of appeal will be
HE, entered into record as HE 3001.
and the declaration of Don Mosher in support of appeal will be
Entered into record as HE 3002.
okay. Thank you.
And I stand for any questions, should you have any.
Not right now. Thank you. Okay. Connie Kruger, speaking as the applicant representative. Oh, there you are. Oops.
I think for the order of proceedings tonight, we should have the appellant give their case in chief, and then any testimony in support of the appellant's case. And then after that, we can go back to the county's case in chief and any supporting testimony for the county. And then upon close of that, the appellant should be given the opportunity to rebut.
To rebut. Okay. All right, so we're going to hear from the appellant. And it looks like Connie is speaking on behalf of the appellant. Yes? No? Where's the appellant? Okay, you did not fill out a thing, I guess.
I did.
You did? Ah. No? Name and address for the record.
Good evening, Madam Hearing Examiner. I'm Scott Porman, 320 East Niter, Suite 204. Coeur
Okay,
d'Alene.
there you are. Gotcha.
It's my understanding that you just now received our appeal brief and supporting declaration. Okay, well, some of this may not be entirely clear, having not had a chance to read that before tonight, but I'll do my best to fill in the details for you. I do want to thank staff, Blake in particular, for his assistance throughout this process. I came into this appeal somewhat late after it was filed last year, and he's helped me get up to speed with the supporting documents and what's in the record already. It's my privilege to represent the Meadowbrook West Road Association and Don Mosher, an officer and director, and Jim Schweitzer, a property owner of the Meadowbrook West property. I'll go through tonight who the parties are, where the property is located, and why that's relevant, history of Meadowbrook West and its recorded documents, the issues that are presented by this appeal, and what we are requesting is for relief in this matter. First, the parties in the property. Blake has identified the applicant's parcel, a little over 10 acres, outlined there in lighter blue, coming off of Clemetson and also with access from Reynolds Road. My clients, Mr. Schweitzer has 3 10-acre parcels over here along the east side, and Mr. Mosier has 1 10-acre parcel above. These properties were created in 1980 by National Associated Properties, an organization you may have some familiarity with. Most real estate lawyers love NAP. They made a lot of mistakes, and we get to clean them up. 1980, NAP acquired 190 acres plus or minus, and they divided it into 10-acre parcels, as you see here, 19 10-acre parcels on Reynolds Road, which zigzags its way up the hill coming off of Clemetson. They did not plat that property. This was done through survey, back in the good old days when a plat was not required. And this is the attachment to an easement NAP recorded for Reynolds Road to provide access to those 19 lots. Don Mosier's lot number 12, and Jim Schweitzer has lots 11, 14, and 15. I'm sorry, 14, 15, and 18. NAP recorded that easement in November of 1980 for Reynolds Road. That's Exhibit 1 to our appeal brief. And they also recorded the same month in 1980 some protective covenants. That's in your record as S05. The easement and the protective covenants used the same Exhibit A map that you just saw. So the easement and the recorded covenants were for those 19 parcels. In 1983, Mark and Marilyn Billions contracted to sell an adjacent parcel to NAP, that adjacent parcel right down here, where Reynolds and Clemetson intersected. In '84, so 4 years after they created this subdivision, NAP amended the easement to revise Reynolds Road. They used the property they acquired from the Billions to make a change to the approach coming off of Clemetson. And that documents Exhibit 3 to our appeal. In 1984, that easement amendment by NAP provided access and extended access from Reynolds to adjoining property to the west, owned by Mark and Marilyn Billions. And I'll get to demonstrating how that reference in the 1984 easement to property owned by Mark and Marilyn Billions is referring to the Smith parcel at issue today. You can see that by comparing Exhibits 4 and 7 in our appeal brief, and you'll see they're the exact same legal descriptions. So in '84, the Reynolds Road easement was extended and access rights were granted to the Billions property now owned by Smith. This is the Exhibit A to that 1984 easement amendment. And you can see they've changed the entrance and the beginning of Reynolds Road to swing through a parcel owned by Billions and then touching on another parcel owned by Billions to the west. That's the Smith parcel. And this, where they touch, is the aerial that Blake showed you just minutes ago. The current Smith residence comes off a driveway from Reynolds Road using this little area where they overlap. Then a year later, NAP, who still owned several lots within the Meadowbrook West development, and other parcel owners of those 19 parcels, adopted an amendment to supplement the 1980 protective covenants. And in doing so, they created the Meadowbrook West Road Association, which is the appellant tonight. In 1992, the Billions parcel, now the Smith parcel, was deeded to NAP. And in 93, association members again amended that 1985 declaration to add property to their association. They added a parcel owned by Knapp, and they excluded a parcel owned by Blodgett. So lands coming in and going out of the association, again, accessed via Reynolds Road, and all part of the same original NAP development. In 1999, Eric Smith contracted with NAP to purchase what is now the Smith parcel. And Mr. Smith took title from NAP in 2001. That's Exhibit 7 to our appeal brief. Immediately after taking title to the Smith parcel, Mr. Smith began paying assessments to the association as a member of the association. He was levied and he paid. In 2004, the association members, the Meadowbrook West Association members, both owners of the original 19 parcels subdivided by NAP and parcels that had been added since then, approved and recorded the property owner's resolution to further amend the 1985 amendment to the 1980 original covenants. And that's in the record as S03. That 2004 resolution refers specifically to now 21 lot owners, increased from the original 19, who belong to the association, and that resolution was approved and signed by Eric and Myrna Smith as members of the association. It is our position in this case that by signing, approving this recorded owner's resolution, Mr. and Mrs. Smith were acknowledging what had always been the case since they took title in 2001, that they were full members of the association, subject to all of the association's documents, including the original 1980 protective covenants. And that's really what this case is about. That is the central issue. It was the director's determination that the Smith parcel is not subject to the 1980 protective covenants recorded by NAP, but that the Smiths are subject to the association documents as if they were two separate things. It's our position, and I hope to convince you that there aren't two separate things. There is one association. There is a set of covenants that have been amended over time, but they all relate to the same property. They started with NAP and 19 lots in 1980. They were amended by NAP to add the association and give the owners of those lots more authority to regulate their road and their property. And they continued to amend in subsequent years, adding new parcels, excluding some parcels, extending easement rights to adjacent lands, all subject to the express provisions of the 1980 protective covenants that allowed for amendments. And I'll show you what I mean. So that's the issue. Is the Smith property subject to the recorded documents of Meadowbrook West? And when I say recorded documents, I mean all of them, going back to the original 1980 easement and protective covenants as they have been amended coming forward. And it's our position, the answer is yes. Here's why. NAP created that 19-lot subdivision in 1980 with a private easement. At the same time, and for the same reason, they recorded protective covenants for those 19 lots. They amended that easement to extend easement rights to the Billions, the Smith parcel, in 1984. They did so because the 1980 covenants allowed for amendments to that document. This is a provision from the 1980 protective covenants that said they are running with the land, they're binding on parties for a period of 10 years unless an instrument signed by a simple majority of the then owners has been recorded agreeing to change the covenants in whole or in part. So the original set from 1980 allowed amendment, allowed extension. And that's what NAP and the other Meadowbrook West owners did in 1985. They exercised that right from the 1980 covenants, and they recorded a supplement to the 1980 covenants, creating an association and making other changes to those 1980 covenants. That 1985 declaration was an amendment to the 1980 covenants, as is very common in subdivisions that have restrictive covenants. The original set adopted by the developer may have one set of provisions. As ownership of the subdivision converts to private individuals away from the developer, those owners, now that they have a vested interest in their subdivision, they want to make changes. So they make amendments to their protective covenants. They make them less restrictive, sometimes more restrictive. They exercise whatever amendment rights the covenants allow. But there's one set of covenants. The original document and amendments recorded subsequently. That's the same thing we have here. That 1985 declaration allowed for amendment like the original 1980 protective covenants, and that amendment right was exercised again in 1993. They adopted another amendment or addendum to add a parcel and exclude another parcel. Again, the copies of those documents are in our appeal record. And then finally in 2004, the association and its members, including the Smiths, approved and adopted the property owners resolution, that's SO3, that again amended the 1985 declaration, which amended the 1980 protective covenants. And thereafter, Mr. and Mrs. Smith continued to participate, as they had before, in association decisions, and they continue to pay assessments and dues, all without any objection. And it is that literally decades-long history of consistent actions and conduct by the Smiths that is legally significant here, because it's just common sense that if you behave a certain way, if you say certain things for a long period of time, people will come to expect that is your position. They will expect you to continue to take those positions, make those statements, and have that behavior. And that sort of common sense idea has been incorporated into the common law under a principle or a doctrine called estoppel. And the simplest way to summarize what estoppel means is you can't have it both ways. If you take a position on an issue, on your situation, and you hold that position consistently for a long period of time, you cannot change your position because it's no longer convenient for you. Others will rely on your behavior, your statements, your actions over time, and they will assume you meant it when you did it for the last 20 years. And the law will not allow people to disadvantage others by changing their position when they've established it over a long period of time. That's estoppel. And it's an ancient doctrine that, again, I think comes from just human behavior. It's what we expect. So Mr. and Mrs. Smith have lived on Reynolds Road for decades. They participated in the association for decades. They've paid association dues. They've participated in making decisions for the association, voting on various matters, all of which are detailed in our appellate brief, and in particular in Don Mosier's declaration. There's the record of the history of the Smiths paying since 2001 all the way forward, as recently as this year, voting on various ballot issues presented by the association, having full benefit of association membership, using Reynolds Road, and again, paying the obligations of members to that association. And now, when the protective covenants from 1980 are no longer convenient for them, interfere with their proposed minor subdivision, they want to claim that they are not members of the association and they are not subject to those original 1980 covenants, when their behavior for the last 20 plus years has indicated that they are. And they can't have it both ways. Madam Hearing Examiner, this appeal really involves a legal question, and it should be resolved by a court. Courts are good at this sort of issue. They operate under rules and procedures that are designed to make sure that admissible evidence, reliable information is presented to support a claim or against a claim. The courts apply rules and procedures with their experience and their training to reach legally valid conclusions when there's disputes, honest disputes, good faith disputes. And courts are often tasked with interpreting old documents, sometimes poorly written, sometimes ambiguous documents. And there's nobody around to explain to the judge, because they were written so long ago, there's nobody left alive that was there when they were written to say, well, this is what we meant. I know that's what we said, but what we really meant was something else. Courts have ways of dealing with those kinds of situations. They happen all the time. And courts don't always get it right. That's why we have appellate judges. That's why we get Supreme Court decisions. And our Supreme Court has said repeatedly that when trial courts are asked to review recorded covenants or other land restriction documents, they first look to see, are they ambiguous? Or do the words mean what they say? Can you discern the meaning of the document from the words themselves without having to go into testimony from someone about what was meant versus what was written? And that's the starting point. If the document's not ambiguous, if you can determine its meaning from the words used, that's what the court applies. And again, with case law, precedent, the benefit of Idaho code, and the court's training and the experience and the arguments that are presented by attorneys, that's where questions like this should be answered, not in land use matters. This is fundamentally a legal question about the meaning and intent of recorded documents. And it's not always just a matter of what the documents say. A judge may determine in a case like this that the protective covenants maybe don't apply to the Smiths' property. Nevertheless, because of their conduct, their behavior, their consistent behavior for the last 20 plus years, they're going to be bound by those anyway. Courts make rulings like that all the time. So this isn't as simple as it might appear on its face. And that's why we're urging and requesting that you make a recommendation to the Board of County Commissioners to deny this minor subdivision and for the commissioners to send Mr. and Mrs. Smith to court where this question belongs, and not to return to Kootenai County with their subdivision until they have an answer from the court of whether these protective covenants that restrict lots to no less than 5 acres, they have an answer whether those covenants apply to their property or not. And why should you make that recommendation? I think it's a fundamental rule, or certainly a fundamental practice, that the persons applying for a land use permission or benefit, they have to show fundamentally that they meet the criteria to make the request. They can satisfy all the requirements of county code, county ordinance, to make the request, including that their request is legally allowed, not restricted by some recorded document. The burden is on the applicant to show they meet the criteria to move forward. And until they meet that burden, they don't get to pursue or proceed through the process. They should not get a decision until they have proven their burden that their request is legally valid, is permissible. And that's why we believe it should be the Smiths' obligation to take this question to a court, get it answered, and then they can come back if they prevail. It really flips that whole principle on its head to require the neighborhood to prove that their covenants do apply, as opposed to the Smiths proving that they don't. The burden should be on the applicant. They're the ones trying to change the status quo. And I think we have presented in our appeal brief and Mr. Mosier's declaration, and frankly, the undisputed recorded documents, we've made a good faith claim and presented valid evidence that those 1980 covenants do apply to the Smiths property, not only because they volunteered to become subject to them, but also because they've enjoyed the benefits of membership in the association for the last 20 plus years, including voluntarily paying association dues and never once raising an objection that, oh, by the way, we'll be members for the road, but we're not going to be members for anything else. It would have been their obligation to say that at some point in the last 20 years, and they never did. And they should be stopped from saying so now. And I think they would be in a court. So, our request is that you send this where it belongs, to district court, and recommend to the commissioners that MIN 2256 be denied until and unless they get a favorable judicial decision. And I'm happy to answer any questions you might have.
What would you say in a situation, hypothetically, the Smiths sold their property 2 months ago, let's just say, and the new owners of the property, unaware of the fact that the Smiths have been paying into the road fund for the last 21 years, they also are not aware that there are restricted covenants that they are obliged to be part of because they weren't listed in the title exceptions, because there was never a recorded document, I guess, that put them under that property. So what happens in that case?
Well, if those new owners came in and applied for a minor subdivision, just like the Smiths have, we'd make the same objection, that your predecessors acted and behaved as full members of the association. The documents we're relying on are recorded, therefore they're notice to the world, whether you're...
But not to that particular site, they're not recorded for that property.
Well, I guess, and that gets back to this fundamental legal question, is, are they attached? Maybe not to the point a title search or a title report would exclude them necessarily. But that's because title officer or investigator may not have the full picture that would be presented to a judge on this case. Like I said, a lot of these questions aren't necessarily resolved by the recorded documents alone. They're answered by behavior as well as the recorded documents. How did people behave? How did they conduct themselves? What did they do voluntarily and without objection for a long time? That answers the question of whether they're voluntarily joining an association, making themselves subject to that entity's recorded documents. These are the kinds of issues a court would look into and has ways of resolving that just a land use matter isn't equipped to deal with.
Okay, thank you.
Thank you.
Where do I go next?
I did submit a copy of my remarks, so that'll be in the record as well.
Yes.
All right. Thank you.
Thank you.
And do we need an exhibit number for the presentation?
Yes.
Could we get an exhibit number for the presentation?
Appellant presentation entered as exhibit HE 3003.
So I believe at this point, any testimony in support of the appellant would be appropriate.
Okay. So let's hope that all of these sheets that we have that say they're either in favor, neutral, or opposed are relative to this appeal. Okay. So the first one I have is Jeffrey and Annette Knapp say they are in favor, but they don't say whether they wish to speak or not.
I did wish to speak.
Okay.
Thank you. I'm a homeowner at 1570 South Reynolds Road in the proposed or in the discussed neighborhood.
And just give us your name for the record as well.
Sorry, it's Jeffrey Knapp, K-N-A-P-P. My wife is not here. I am in favor of the appeal. We moved into the development approximately 5 years ago. And at the time, certainly I was under the impression that all of the homes that come directly off of Reynolds Road, which in this case it does, were all part of the association. And while I don't happen to know the the couple involved in wanting to make the changes, it just strikes me as another count against not only our development, but even the area that is being built upon so quickly. We've had issues with water in the development, crowding, speeding on the roads, all these kinds of things. You know, while we're not against development from occurring, we think it does need to occur in a manner that's consistent with all the things that were agreed to at the prior time, meaning those that joined the development or came into development came in with under one document, and that one document is the document that the association has been operating from, certainly since I've been there for the last 5 years. That's it. Thank you.
Okay, thank you. Okay. Don Mosher, in favor, wishes to speak.
My name's Don Mosher, 1619 South Reynolds Road. I am a member of the Meadowbrook West Road Association, MWRA, have been for 10 years, a board member for 6, and the registered contact and records custodian for over 4 for the association. I'll leave the connections Scott made to the documents, but we voiced our disagreement with the county from the start, maintaining that people purchased in this area to spread out 10-acre lots, couldn't be subdivided into less than 5, and the lots were laid out as less than 10 acres, 9 point whatever. So no subdivision, no more neighbors, no more development there. Mr. Smith has actively participated, paying dues, signing documents, casting votes, and receiving the benefits for over 20 years, as Scott said. He's always asserted himself as a full-fledged member of our association and has never claimed or insinuated that he was anything else or was exempt from covenants or any of that. I also have a statement from a veteran MWRA member who was a property owner on Reynolds Road and actively involved in various association roles from 1984 to 2019. She also served on the board from 2011 to 2017, and I'll paraphrase, but she described the Smiths as not only participating MWRA members, but were part of this community in every sense of the word. The Smiths signed the amendment March 3rd, 2004, which subsequently notarized and recorded on April 21st, 2004. The amendment, the latest of several that Scott linked, ties back to our 1980 covenants. That's always been our position. And that amendment was entitled Property Owners Resolution to Amend Declaration of Road Maintenance and Covenants for Meadowbrook West. We feel it binds the Smiths, even though their actions do, but that binds them legally to the 1980 covenants. Mr. Smith is an attorney, therefore held to a higher standard. He can't claim he didn't know what he was signing, and nor can he masquerade as a member for MWRA for 20 years and now claim that he's not, or he's only a partial member. There's people up there that could be damaged, property values, whatnot. Really, this thing should have never made it this far.
I have to cut you off. Your time is up.
Thank you.
Thanks. Robert Haynes, in favor, wishes to speak.
Good evening, Madam Hearing Officer. My name is Robert Haynes. I reside at 2571 South Reynolds Road, Coeur d'Alene. My wife and I purchased our property and moved in 1999, so we've been there for 25 plus years. And we understood when we purchased the property that there was a road association because it was a private road. Funds had to be generated to do maintenance on the road, to do snow removal and that type of thing. And we also understood that there were covenants that regulated the things that we could and couldn't do. As has been mentioned, Smiths have been fully participating members of the association since they came in. I was told by Bernie Knapp, who was the road manager at the time when this took place, that Eric was told that if he wanted to use Reynolds Road to access his property, that he had to be part of the association. I want to answer a question that you asked of Mr. Poorman. If the property were sold to somebody else and they were not given information about what the restrictions really were, it seems to me that the onus for paying for that resides with the person who sold the property, not the people who are occupants of property around it. We wind up being adversely affected by having more lots developed, road traffic, water issues, those type of things have been mentioned. And again, the Smiths have been fully participating members of the actions of the association for as long as they've been there. Thank you.
Thanks. Victoria Baumann, in favor, does not wish to speak. James Schweitzer, in favor, wishes to speak.
Good evening, Madam Hearing Examiner. My name is Jim Schweitzer. I live at 1854 South Reynolds Road. I first purchased land. I believe the Smiths made an offer or closed on their property in August of 2001. I made an offer in September of 2001 and closed in late February of 2002. So I've owned the first 10-acre piece for 23 plus years. During that time, the first piece that I purchased, it has more road frontage than anybody else. And the reason I bring that up is because part of being in the association means everybody who's up there has to pay for maintenance. The very first bill I got, I was in college in Atlanta, Georgia, going to Georgia State, excuse me. Reason I bring it up is there was an assessment in February for a chip seal. And I was very cautious at that time about everybody was all in that the association, meaning the members, bore the costs for road improvements. And I've been that same way for 23 years. I purchased the next piece of property in probably 2016, 17. Then I just purchased another piece of property 2 years ago. The reason I bring it up is during this 23 and a half years, I have never, and I'm on the board currently, I've never been advised or ever had a conversation. I've known almost every road manager since the last quarter century. Bernie Knapp that Mr. Haynes just talked about, I used to talk to him from Georgia. I've never been told that anybody who lived and accessed Reynolds Road wasn't bound by both the road maintenance agreement and the covenants. I'm the largest landowner up on Reynolds Road. I would argue that if anybody had acted a certain way for 20 plus years and now decides to change, I may want to claim that I've been damaged. And this is why it's important to me, because I could argue that maybe this affects my real estate value. I have a lot of money invested up on Reynolds Road. I have a lot of history with it. I've never heard this assertion before this minor subdivision. I just ask that during my 23-year history, I've witnessed him all the way back to 2002. My name's right next to his, Smith, Schweitzer, on dues for a chip seal that goes back 23 years. Nobody's voluntarily paying that. You're part of it or you're not part of it. If you receive benefits, I've relied on this. Mr. Portman argued this should be in front of a judge. I agree. Mr. Smith is an attorney. I've known that. This is one of these deals where I understand I'm a big property rights advocate. What's good for one may be good for others. I could have exempted myself when Mr. Callahan overlaid back to the agricultural into the 5 acres. I could have done it on all 3 of mine. I didn't. You cut me off.
I'm sorry, that was your time. I graduated from Georgia State too. Travis Irvin, in favor, may wish to speak.
Thank you. My name is Travis Irvin. I live at 1303 South Reynolds Road, and I'm in favor of the appellant. I'm one of the new kids on the block, and I moved there about 12 years ago. And as part of escrow, I signed the documents, with the escrow company for the association and the CCNRs, which were one document really. Moved there because I wanted space around me, not necessarily, just a small postage stamp lot. And some of the things that stood out to me with signing the association documents was that it had written in there that the minimum subdivision is 5 acres, or to do a lot split was 5 acres, as well as you needed to go before the rest of the road association and have a 4/5 vote in favor of the proposition. So, never to have seen a document from the developer, or Eric in this case, asking to subdivide the property, even though he's been a dues-paying member, ever since I came on the scene. I was a road manager there for a while too. So, I was privy to who paid, who didn't pay, and all that. And the Smiths always paid. One of the things that also concerns me and why I purchased my lot was because of water. And as you know, during the rezoning effort, that was a key issue out in the Cougar Gulch area. That, and quite frankly, I like the wildlife that comes in and you're able to see it. And I think Jim even mentioned that, it damages property, in more ways than just the value of the property. It's the lifestyle that we chose to move up there. Talked about a lot of things you've already heard, so I'm just going to skip over my notes. And I think one thing note was when the association was, or the lot splits were originally done, they're like 9.9 acres. So it really makes the 5-acre split moot in that case, just because you can't get 2 full 5-acre parcels out of it. And one of the reasons, I noticed at the very end of all the discussions when the rezoning went through a few years ago was that this was carved out. But I believed as a property owner, I'd be protected with our CCNRs because all of our lot paying members were all up to date and had always been paying. So with that, I'm like Jim, I'm concerned over my future property values. People buy out there wanting to have space around them, not just another home to stare into. So with that, and the water issue continues, but I cut out a lot of things that I had written down, but you've already heard them all, so thank you very much.
Thank you. Greg Grant, in favor, may wish to speak.
I'll pass.
Okay. Carla Grant, in favor, may wish to speak.
Hi, I'm Carla Grant. I live at 1779 South High Ranch Road. So don't live on Reynolds Road. I am not a dues-paying member of their association. However, our property abuts the south end of these. So this is a narrow gulch that comes down. A lot of crowding would happen with this. There's also a year-round creek that runs through these properties. That's a concern of mine, and maps don't necessarily show that there's a pond and a creek that runs through here. So water is an issue up there. Traffic on the roads is an issue. And like these good folks, our neighbors at Reynolds Road, we moved there in 1997 because we wanted some space around us. And these two properties would encroach us probably more than anyone else here in the room. Thank you.
Okay, thank you. Karen Irvin, in favor, does not wish to speak. Tom Whitehead, in favor, may wish to speak. Did you come off the ski slopes to meet?
I came straight here.
There's that telltale sound. Swoop, swoop, swoop.
I live 1415 South Reynolds Road, and we moved there about 13 years ago. And from day one, we knew that the properties, were less than 10 acres, so we'd never be able to divide our property because we looked at the information on there and it said they had to be at least 5 acres to be able to divide it. So, and water and everything else in that area is very problematic. And I just want to make sure that this doesn't get divided. Thank you.
Thank you. Okay. Mark Shepard is neutral and does not wish to speak. Eric Smith, opposed, may wish to speak. Oh, okay.
And so maybe, Madam Hearing Examiner, we can have the county's case in chief at this point, and then any testimony in support of the county's case.
Okay, sounds good.
There are two, we mistakenly put opposed, we're actually in favor. We were thinking we were opposed to the subdivision.
Okay, so are you the sellers?
We're the Fetzers.
And are you, did you mistake your, okay. Douglas Sellers is in favor and may wish to speak. Do you wish to speak? Okay, come on.
Name is Douglas Sellers. I live at 1935 South Reynolds Road. I'm the newest kid on the block. Bought property back in 2020, and I'm thoroughly enjoying it. I don't wish to see any more development up there. I'm in favor of property rights, but as an owner, you need to take into account the community that you live in and, you know, your fellow neighbors. So that's why I am in favor of the appellant.
Okay.
Thank you.
Thank you. Stephanie Fetzer, you are in favor and you may wish to speak.
Just briefly, my name is Stephanie Fetzer. I live at 1217 South Reynolds Road, and we might be able to fight about who the newest kid is on the block. I'm not sure. We also moved in 2020. And I just wanted to say it was very clear when we signed our escrow documents that we were joining the road association. There was no equivocation. It was clear what we were getting ourselves into. And for all the reasons that have been previously stated, I'm in favor of the appellant. Thank you.
Thank you. And Gerald Fetzer is in favor and may wish to speak.
Yeah, I don't have any further comments.
Okay. All right, then that's all of the comment sheets I have who are in favor of the appellant. Okay. Anybody on Zoom? No? Okay.
All right, so beginning the second half of my presentation, we'll go over the staff analysis and recommendation. As you heard, the appellant wishes to appeal or overturn the approval of the minor subdivision on the basis that CC&Rs restrict the minimum lot size to 5 acres. As noted here in the 1983 protected covenants. After review of the related documents, the Smiths did sign the 2004 Property Owners Resolution amended declarations of the road maintenance and covenants. Our legal counsel and staff believe that that document only relates back to the 1985 Declaration of Road Maintenance and Covenants. It does not actually, as noted here, does not actually relate back to the 1983 protective covenants. So while they are part of the association, we do not believe the protective covenants are applicable. As exampled in the next slide, which you have seen this map here before, we did overlay that map with the existing parcels in the area. The subject parcel in question, being here in orange, is clearly outside of the mapped covenants and agreements. So it is for that reason, since no document has been produced that suggests they are subject to those CC&Rs, it is staff's position or recommendation that the appeal is denied and the decision is by the director is approved. And I stand for any questions.
Did you happen to have a title report on this property? And there's no reflection of CC&Rs recorded on the title?
Not that I saw, no.
Okay. Thanks.
So at this point, we could entertain any testimony or anybody that would like to speak on behalf of the county's case or in support of the county's case.
Okay. And I don't know that I have any sheets that are reflective of that.
I believe the applicant wanted to speak first.
Okay, yes. Sorry. Eric Smith.
Thank you, ma'am. Eric Smith, 2835 South Reynolds Road. If I can have the that screenshot that the staff, the bottom right-hand one. Oh, I didn't, okay, I only got the one, okay. Well, let me start from the beginning since so many of my neighbors are here. First of all, my parcel is more than 10 acres. And when I bought it, there was a post from NAP on the property that was not that map. It was the Highview Ranch NAP property, and it's the document that was recorded on my property and in my title report. It's the one that my realtor showed me, and that's document 1150550, a completely different map than that NAP. And that was on my title report. And that's who I talked to and who my realtors looked at. And in the beginning, when I sought to get a building permit and a certificate of occupancy, they originally gave me a Clemetson address, Clemetson Road, the county road. And Blake, can we make that any bigger? Just and show the bottom right-hand part. So as everybody's pointed out that Reynolds, oh, did I do that? So as everybody, and this accurately reflects that Reynolds Road doesn't come all the way to my property. So here, because my property crosses Clemetson and then Highview Ranch here, where the Grants live up here. So I had this Clemetson address, and I was going through with my builder, and we were looking at different spots, looking at the options for having the fire trucks being able to turn around and the radius of turns and things like that. And then he said, you could approach the people on Reynolds Road. I approached the people at that time and said, I wanted to use the road, and they said, fine. So then I went through the process, got my address changed. I had to make a permit and everything and had it be a Reynolds Road address. And then from the beginning, I said, I volunteered, by the way, to, if I'm going to use the road, I'm going to pay for it. And so I voluntarily started to pay and be a part of the maintenance of the road, and I always have. That's the one thing that's been correct here is I have paid all my dues over the years and done everything possible, even though I only have a short little stretch there. So looking back at all the different, I've also owned more than one property here. I used to own a pond that is now next to my property. It's right here, and manage that pond, and I'm very familiar with all that wetlands. And the parcels that I'm trying to switch off are dissected right here by Highview Ranch Road. So the idea that anyone on Reynolds Road will see the entrance to this property, will see any traffic to this property is impossible, will even see the home sites is completely impossible. As Mrs. Grant said, she's the only one that may even be able to see it. It's dissected by geography and roads, and it has nothing to do with Reynolds Road. It won't impact them at all. And as far as my stewardship of the property, in addition to that first pond, that I owned for over 20 years. We had a fish and game survey done on that for frogs and salamanders. I've applied for, through the Department of Water Resources, got 2 pond permits for the 2 new proposed lots. I think it's lots 1 and 2 now. And I had a hydrology report as part of our application on where there was the wetlands, where we needed to stay away from, and then where I could use those 2 pond permits to improve those wetlands with 2 ponds. So in addition to that hydrology report, I also had another hydrologist come out and survey the underground to confirm that that whole drainage there is a completely different water system for us poor people who do live up on Reynolds Road, because the water is very poor up there. We go through a lot of water filters, and I've had 2 different wells on my property, and we've all struggled with it. Over there's not any problem because it's a completely different system, and it's low, and it's a wetlands. So that's some of the history. When I moved there, I would not have bought a piece of property that had CC&Rs, first of all. And I didn't know anything about it. For years, I didn't know anything about it. I always assumed I just volunteered. The document they're trying to hold against me, the 2004 document, the board at that time came to me and asked me for free legal advice and asked me to draft the document. And I did. I volunteered to draft that document. And because I was part of the road. Nobody here was on that board at that time. And so I voluntarily drafted that up, and then they asked me to sign it to be neighborly and be part of the community. And I did. And I have been part of this community in every way. But I had no record notice of the CC&Rs for years. And when the county went through its rezoning based on citizen petition, I exempted my property out of there. So that should have been some notice that I didn't think that I was obligated by CC&Rs at that point to follow through with that. And the fact that my parcel was greater than 10 acres. Record notice is important. Not having record notice of something means that, am I gonna forever now have a cloud on my title to be able to sell my property because of these proceedings? And that's, of course, impossible. Idaho is a record notice state, and they're bound by that, and I'm bound by that. I've never had any levies against me. I've never had anybody ask me about this. They said that I should have been telling them that I wasn't bound by these properties, but I've never heard until tonight and this appeal that there was some kind of perceived legal case against me, and I don't know of any. So some of the history on these documents, it's not exactly as it's been set forth. So again, I've cited the document that actually touches my property, and that's the Highview Easement Ranch. And I'll even show it just so you can see that it's another NAP map, another very bad map. It's not to scale, it's not accurate. The map that we're looking at is not to scale, it's not accurate. It doesn't touch my property. This one clearly touches my property. You can see in the beginning of that, it doesn't come close to showing where Reynolds Road really is, and Reynolds Road's been in the exact same spot. I will point out that my homeowners association also just recently tried to sue these people right here to not let them use the road, and lost that appeal in the district court. And those people are all using Reynolds Road now for some of the same legal reasoning that has been presented here tonight. So the documents that have been presented tonight, the protective covenants, 861245, that's the one that doesn't show up on my property, has never been recorded against my property. It describes the property, and that's it. It says the property described as. It doesn't say that you can become subject to these protective covenants in any way. There's no exceptions. It just describes the property, and it's recorded. As opposed to the Meadowbrook West easement, let's see here, declaration of road maintenance and covenants for Meadowbrook West, the one that they asked me 20-some years ago to amend, that one says, the association may extend the conditions of this declaration to owners of property on adjoining roads, if any, as requests are received and as the association deems beneficial. That's what I took part of. But as our neighbors who won the recent lawsuit over here, they're not paying anything. I pay. I'm paying my way through it. So I don't think I'm even obligated to pay. But I have, and I have all these years. This, the one I was quoting was 1067823. That's the declaration of road maintenance. That may be extended to other people. The protective covenants have no way of being extended or improved upon. It doesn't mention how they can apply to any adjoining landowners, and they are that. They are actually CC&R's protective covenants. Protective covenants run with the land based on record notice. The road maintenance and covenant agreement says, and so there was this, they told you there's only one, and there's one, and there's one, and I signed up for one. But there's not. There's two. And I signed up for just one of those things, and that's what I was using and what I have used and what I faithfully paid for. And that was the right to use the road, and since then we've made mailboxes right below the road. And all the amendments they're talking about are actually my neighbor's property in 1984 right next to mine. So my parcel's never been attached with that. The one, I think, confusing let me keep looking here. So that's my legal argument. The equitable argument that I heard tonight for the first time, promissory estoppel, that I made some promises to these people that I'm unaware of, except that I would be a faithful neighbor, I would use the road as intended, I would pay for it to be kept up. I had no idea I was signing on for CC&Rs, that I had made this promise to someone that I was going to be obligated to the CC&Rs, especially since I have more than 10 acres. It doesn't matter to me. I can still subdivide my property. I can choose to do that because I have more than 10 acres. And if they don't, that was the original developer's intent, but it's not mine. But then somehow that they would be damaged or detriment. I wish you could see it because, as Ms. Grant pointed out, it really is a tale of two parcels. Where my house is, it looks like it should be on Reynolds Road, but the rest of it is a ravine, mostly covered by wetlands that no one really uses or sees. It's divided by a road. I will barely see from parcel 1, 2, and 3 in my application. I will barely see the difference between the two because they're so different because of the geography and the wetlands. So there's just no possibility that anyone on Reynolds Road would be somehow prejudiced or damaged in any way. I know you received a lot tonight. I'm willing to ask any questions, but that's all I have.
I don't think I have any questions of you. Thank you.
Okay, thanks.
Yes.
Madam Hearing Examiner, I'm David Callahan, Kootenai County Community Development Director. I would just offer that because we've received late-breaking information that the staff was not able to review with our legal counsel, if you have any concerns whatsoever, that you would like to have our legal counsel weigh in on that information, I would offer up that the proper thing to do would be delay your decision until our legal counsel can opine, and then we could, and actually possibly even continue tonight's hearing to have Mr. Braden speak before you if you'd like. And that way you would have a full and complete record that the county can offer. But that's really your call.
I think that's an excellent idea, actually, because we do have considerable documents that we, to do justice to this matter, should review.
Well, and especially since it sounds like it's going to end up in court. Because the first thing the courts tend to say is, have you properly exhausted local remedy?
Yeah. Okay. Is there anyone on Zoom? No. Okay. Then I think that's what we'll do. We'll continue this hearing for a date to be, yes. I don't get to do appeals very often, so pardon my lack of appropriateness. Yes, you may come and do a rebuttal.
That's quite all right. Welcome to our world. I just wanted to address a couple of things. Here's a shocker. There's lawyers who disagree with each other. Mm-hmm. Myself and Mr. Smith and Mr. Braden apparently have opinions about this and aren't the same. And guess what? That's what courts are for. You asked a question about a title report. And Mr. Smith indicated when they purchased, their title report did not reference or disclose this disputed protective covenant from 1980. That's not a surprise to me. Title insurance companies generate title commitments or policies. And you may know this, but there are a long list of all the things that the title insurance does not cover. If they do their job right, it's like Swiss cheese, but it's all holes. There is no cheese. They don't cover anything because they list everything that they don't cover. And they make a comprehensive list. And sometimes title insurance companies make mistakes and they miss things. And then they have a claim that they have to cover because it's insurance. If they fail to exclude something in a title insurance policy, they have to cover a claim for that document. Maybe Mr. Smith has a claim with his title insurance, and that's what the title insurance company will decide. Title insurance companies are really good at excluding everything they can think of, and they have.
But they're usually very good at picking up what's recorded.
They are. They have to be. They better be. They'll be out of business soon if they're not.
And so this wasn't recorded on this property.
Well, yeah, and again, that gets to the fundamental legal question, is if you stop at the 1980 protective covenants, the answer is you're correct. It wasn't recorded. If you keep going, if you follow and connect the dots of the subsequently recorded documents, you can make an argument that these 1980 covenants were pulled forward.
But the exhibits of the property description and the written description are still the old property description. They don't include this property.
Yeah, and I guess that's more detailed in my brief, that there were amendments after 1980 that added new parcels to the original 19.
But didn't include them in a description. Meets and bounds description or exhibits.
No, actually, I think they did. But again, that's something you'll probably see in the more detailed document. I did also want to share with you just a little bit of my experience on this issue. And I'm sure you know Carl Granrath, the other hearing examiner. I've made this argument before to him in the appeal of a minor subdivision. Only that time I was on the other side. And I was arguing, pay no attention to those restrictive covenants. They don't apply to this parcel we're trying to subdivide. And he listened carefully, and in his recommendation to the county commissioners, I'll quote for you what he said. This was in APP 22-0003, and all of this is in my brief. He says, quote, "As I stated in my recommendation for APP 21-0003, and as argued by the appellant, it would be unwise policy for the county to approve applications that conflict with known restrictions on property. Such actions cause unnecessary downstream effects, such as litigation and other legal disputes. Approving such applications puts the onus and expense of filing appeals on neighboring property owners. And while approval criteria for minor subdivisions does not explicitly address CC&Rs or other similar restrictions, I would strongly recommend that the department avoid entanglements in these legal matters and deny applications that conflict with then recorded encumbrances on the property. Such disputes or questions of applicability should be hashed out in the district court." And I think Mr. Callahan's predicting the future accurately. I think that's where this is headed. The question is, should the county make a decision first or just send Mr. and Mrs. Smith to court where this question belongs to then come back if they prevail, versus running us through the process of another hearing with the county commissioners, a request for reconsideration, and then judicial review. We can avoid a lot of unnecessary legal gymnastics if the county adopts a rule, and I'm urging Mr. Callahan to take this into consideration. Just adopt a rule that says if an opponent comes forward with a reasonable question about restrictive covenants or some other similar recorded document, then full stop on the application until that question is answered. It kind of reminds me of the situation which happens all the time. There's a neighbor-to-neighbor dispute about a boundary, and the police are called. And the police are trained to say, we're going to stop where you are, we're going to maintain the status quo, and whoever's trying to change the status quo, go get a judge to answer the question, and then we'll enforce the judge's order. The cops don't get involved in deciding boundary disputes. They're trained not to, because it's a minefield. You can't win. That's what courts are for. Go get a judge to answer the question. Come back when you have the answer. And it's a good rule. I think the county should adopt a similar policy. Thank you.
Okay.
Questions?
Nope. Thank you. Any staff?
Yes.
Rebuttal?
Madam
Yes.
Hearing Examiner, just for the sake of clarity, having done this for some 45 years now, meaning this kind of work, I can safely say it is impossible to write regulations and policies that address every contingency. Here, we've relied on our legal counsel, who is fully aware of all of the issues that have been presented by both sides. And I, for one, don't play legal counsel. I defer to my legal counsel. So that's why I believe it might be useful to have Pat weigh in before you make a decision.
So noted. Thank you.
Thank you.
Are we done here? Okay. Thank you. Then that concludes our hearing this evening on APP 24-0001.